Hi, I'm Steven Svoboda. I'm speaking to you from California in the United States. And it's good that this conference is happening. It's unfortunate that we're not able to go to the lovely country of Australia, where I was twice in 2000 and 2003, two very amazing visits. And I do realize that New Zealand's a different country, but I was in New Zealand in 2014 and 2017. And yeah, really hoping to return back to Australia this year, now able to do it only on video. In any event, I have the mixed blessing of talking about this odd thing that we somehow started doing in a medicalized version in the 19th century called male circumcision, this weird thing that we would never be doing if a series of historical accidents didn't lead to various reputable doctors in the 19th century thinking that it was a cure for basically everything, and this was related to the severe anti-sexual feelings at the time, which are hard to even understand now because we're in such a different era. I mean, it's hard for my kids to even understand that I didn't have a cell phone when I was a kid. I mean, trying to talk about the 19th century is crazy these days. You'll see behind me, I have all these posters of rock concerts I've been to, the Red Pill movie where I met my wife, which I was in, talking about, again, this circumcision topic. Great movie by Cassie J. I'm sure you all know about it. Anyway, so the circumcision, we're still talking about it. The boundaries of what we're talking about have changed. There's been some more willingness to hear about the topic and to hear about things relating to males in general, which we'll get to. So lately, there's just been a complete outpouring of articles about genital cutting in general, male genital cutting, also known as circumcision, female genital cutting, also known as FGM, intersex cutting that more and more people are hearing about on intersex people who are born neither 100% male nor 100% female. And then this odd cosmetic FGM or FGC, female genital cutting, that happens in first world countries, typically to wealthier women, and somehow is tolerated and approved, whereas the other form of FGM, which is considered bad, is not approved, and there's all sorts of economic, sort of social class, and also racial biases perhaps built into that differential opinion. That's a side issue we won't really be delving into much, but genital cutting, public opinion is shifting. Torture can now be discussed, which is great. I decided in 1996, my first presentation in Lausanne, Switzerland, I couldn't really talk about male circumcision as torture. It just seemed like something people weren't ready to hear. And you can be right, you can be wrong. Slavery can be wrong. You can be totally right about that. But if it's 1840, you may have to be nuanced in how you present your arguments. Well, most of us, perhaps all of us, felt the same in 1996 about circumcision as torture. Well, that's changed. The goalposts have moved, to use an American football saying that no one outside of the U.S. is probably going to be able to relate to. But, well, you have goalposts in soccer, also known as football. Anyway, so the goalposts are moving. We're talking about consent. We're talking about medical necessity, carrying strong weight in deciding should we be able to perform genital cutting. Well, generally we should not, in many people's views, including people who aren't really activists on this issue. And many people are saying, not everybody, but the majority of the views around the world, and the overwhelming view in Europe has become that medical necessity is required to justify any change of someone's body before they're able to legally consent. Makes sense, right? If it's not medically necessary, they can wait till age 18 and they can decide then, or whatever the age of consent is in the appropriate country. So I'm going to talk about two very interesting cases that were decided by the same judge in the U.S., one relating to FGM and one relating to MGM, male genital mutilation or male genital cutting or circumcision. We'll get into all of that later. As background, yes, these three or four different types of genital cutting it would be 4 if you count the FGM in Africa and the elective FGM in the US as 2, or in the developed world as 2 different forms of cutting. So either 3 or 4 forms of genital cutting have been discussed. There have been so many different prisms used to reflect the different angles that are the analytical points, that one almost thinks that there's no more that can be said about the topic, but in fact there is. It's fascinating, still interesting to me after 24 years of this work, and my plan was to get out after 7 years, so 24 years is way beyond my exit plan. But religion, psychology, culture, gender, that funny topic that is getting more complicated as we speak, all of these issues and many others, government, regulation, law, are wrapped up in the circumcision topic. And the quest for equal protection, which is a U.S. term based on the 5th and 14th Amendments, the relevant part here is that the sexes, male and female, should be treated equally, fairly, based on the Bill of Rights, the 5th Amendment, and also the 14th Amendment to the U.S. Constitution. And many human rights documents have equal protection concepts. Many foreign governments, laws, or constitutions have equal rights, equal protection concepts. So somehow we've had 30 U.S. states passing laws forbidding FGM, as well, of course, as many foreign countries, and no country forbidding male genital cutting. One can speculate on the reasons. It's been unfashionable to think about harms that affect males, at least until recently. And that's been an interesting development, sort of, that's been paralleling the increasing openness to talking about torture, which is that this conference, the International Conference on Men's Issues, brings up men's rights issues, and men's rights and the genital autonomy movement are moving closer together, which is very exciting for a number of us. Mike Buchanan has labored tirelessly on this issue, as have many others of us, and not always with universal acclamation from every single person in the movement. Shockingly enough, those of us who support genital autonomy support a gender equal approach to genital cutting, and in many cases don't think that really anybody should be getting cut prior to age 18 unless there's a very rare case of medical necessity, which frankly almost never happens. But I'm not a doctor, it could happen. It's very rare if it happens at all. Those of us who feel that way are getting more and more common, and lay people are just getting on the internet, looking around and saying, what the heck? Why would we ever do this thing to our healthy child? That's a very good question. My son was born in Guam, which those of you outside the U.S. probably know U.S. politics better than we Americans do, I'm sorry to say, but Guam is a U.S. territory. Of course, a very important battle in World War II was fought there in late 1941. Anyway, my son was born on Guam. The nurse asked me, I think it was 5 times, maybe 6 separate days, separate occasions, do you want your son circumcised? I'm pretty sure if I'd ever answered yes, there wouldn't have been repeated questions, it would have been done. I said no every time. And I was trying to be cool. I was trying to focus on my son's birth rather than my activism, which I'd already started several years previously. But I finally said to the nurse, you do know there's no medical reason for doing this, right? And she quite chirpily responded to me. I remember it like it was yesterday. Oh, yeah, I know. Well, the natural next question, which I did ask her, was, why are you asking me if I want it done? And she said, well, the parents want it done sometimes. Well, what other procedures do we defer to the parents on? I'm pretty sure the answer is 0, or very close to it. So this topic might seem to lead to departures from a straight and narrow path. And I have my presentation here. I'm making my way through it. I'm definitely having a few detours of my own, but the detours will lead us back to the point we're trying to make. It all will work out. And so back to these 3 or 4 different kinds of genital cutting. There are laws. There are laws, as I've said, around the world and in the U.S. forbidding female genital cutting. Interestingly, there are laws in the U.S. Legislators, for some odd reason, in several states in the U.S., including Illinois, seem to have been concerned that somehow male circumcision might be illegal. Now, why would that be? I can't imagine. Of course, I can't imagine, obviously. Way back when, legislators in several U.S. states saw fit to pass laws saying, well, actually, male circumcision isn't illegal. It's not subject to, for example, prohibitions against child abuse. And I leave it to, as an exercise to the listeners, why these laws would even be necessary. It's very interesting they're on the books. So male circumcision is currently tolerated everywhere. We have a very amazing effort in Denmark by Lena Nyhus and colleagues, which may shortly result in Denmark putting some level of legal restriction or prohibition on male circumcision. Hasn't happened yet to my knowledge. There was an effort in California, a very valiant effort. I was present in the courtroom when the judge more or less overruled that effort. There's an effort in Iceland which is proceeding apace. So where are the people coming from that argue that there's justification for treating male circumcision and female circumcision differently? Let's just say conceivably maybe they have a point, or let's just look and see if they do. To meet someone's arguments, it's good to meet them on their turf, so to speak, or at least enough to confront what their reasoning is. So there's a lot of reasons for it. I think there's a very differential view of males and females, which we're probably not going to get away from completely anytime soon. This new gender landscape that we now have opening up for us is certainly changing. The rigidity, perhaps, with which we view male and female as two completely distinct islands and nothing in between. Intersex people are also, just by being themselves, and non-binary people, just by being themselves, are opening up those previously, at least from certain people's perceptions, previously pretty rigid barriers. So now let's get a little bit into my story. And the story I have to tell is about a moment when I scratched my head. So as we'll talk about in a second, there was a case in 2019, last year, a U.S. federal case that many people probably heard about, where a federal judge overruled the 1996, although it went into effect in early 1997, federal law against female genital cutting. So the interesting thing about that was that I scratched my head and said, that guy's name sounds familiar. Where have I heard of him? Was he one of those famous judges we heard about in law school? No. Bernard Friedman? No, that wasn't it. Then I realized where I'd heard about him. We'll talk about that a little more later. It was another case that I'd had with him 17 years previously, in 2002. So, telling the story out of order, but in the way that probably makes the most sense, if this were a movie, which I guess it is a movie, actually. There's an Islamic sect that I certainly had never heard of before, the Dawoodi Bohra, an Islamic sect that practices both FGM and MGM, both FGC and MGC, male genital cutting and female genital cutting, both for religious reasons. And it's a very interesting situation because the form of female genital cutting that the Dawoodi Bohra practice is quite minor, often leaving no physical evidence that genitals were altered in any way. But the form of male circumcision that they practice is quite invasive, and both are done for explicitly religious reasons. So let's see. I'm going to leave out some of what I was going to say for right now. We'll see if it becomes relevant later. Continue on with the story. we had this federal law that had already been passed in the mid-90s, and to most observers' perceptions, this was a great thing, outlawing female genital cutting. It was probably an unnecessary law because existing laws on the books against assault and sexual abuse and other things already would have outlawed it, properly interpreted, but it wasn't certainly negative in any way to have another law stressing our opposition to female genital cutting. Now, why we wouldn't extend this to males, that's another question that, of course, I was thinking about, many others were thinking about, even back when the law was passed in the 90s. But leaving that aside, it was a good thing that this law was passed. I remember being at a press conference that the leading genital autonomy organizations, we didn't call it genital autonomy back then, more than 20 years ago, but the leading genital autonomy organizations were at, and this was a joyous occasion. So the law wasn't really tested until much more recently. We had a case where in Michigan, several people, some physicians, parents, were convicted of being involved in some cases of female genital cutting that were related to each other. And so Judge Bernard Friedman's an interesting character. He was born in Detroit in 1943, served in the U.S. Army, reaching the rank of lieutenant after a stint in private practice as a lawyer and then as a district court judge. Ronald Reagan nominated him to a seat in federal court for the Eastern District of Michigan. And Judge Friedman did preside in, as I said earlier, one important case about male circumcision that I was involved in directly, and then the case about FGM. So, and Judge Friedman also had another very important case in between those two that we'll talk about in a second. In the summer of 2002, Judge Friedman, however, found his way to New York as a visiting judge. And he was brought in to decide the backlog of the oldest cases that hadn't been decided in the Federal District for the Southern District of New York in Manhattan. And one of the cases that he had to decide was a circumcision case, which there had been various procedural delays, and I was still living in the U.S. territory of Guam at the time, but I moved to Staten Island for a few weeks and was one of the lawyers in the case. And it was an interesting one. We ended up deciding to bring it as a federal civil rights lawsuit because the hospital was government funded and had a practice of systematically inducing consents, as they call it. I don't like that term because it isn't the child who's consenting. It's more properly called permission, parental permission. But in any event, consent is the word that's generally used. The hospital was going to mothers shortly after they gave birth. In many cases were still drugged up from the typical hospital birth, gave them the consent form in English, which many of the mothers didn't really speak, didn't translate it. Page 1 was the business part of the consent, saying all the things they were ostensibly agreeing to. Page 2 at the top just had the signature line, and apparently I shouldn't say apparently, this is actually fact based on our investigation. The hospital was giving it to the mothers, saying, sign this so your child can go home with you, and leaving it at that. And the mothers did sign, and that was what the hospital was doing in what was then the most racially diverse square mile in the world, in Queens. So I speak pretty good Spanish, so I was the one the member of our team interacting with the Spanish language newspapers. Every morning they were interviewing me in Spanish, and it was broadcast on TV, and there are also daily newspaper articles that I was interviewed for in the Spanish language newspaper. And meanwhile, we were interviewing all these plaintiffs, building our case, trying to build a class action case. Now, class actions are a very difficult thing to do legally. There's a whole set of requirements that you have to satisfy, and they're not easy to satisfy. You have to essentially show that the different cases you're trying to combine are very similar, so similar that combining them into one case is going to promote judicial efficiency and not result in a miscarriage of justice for either the plaintiffs or the defendant. And So it's not quite an impossible task, but it's close to that, and it does become impossible if you have an unsympathetic judge, which we very quickly realized Judge Bernard Friedman was. He just never liked our case from the beginning, and there really wasn't anything we could do to change his opinion about that. So we, in the end, were unsuccessful at getting the class action authorized, and additionally, we were unsuccessful at getting permission to bring in these other people who'd had similar things done to them as witnesses in the core case, which was the case of a young boy who I'm going to call Dennis. That's not his real name, son of a Greek man and an Ecuadorian woman. And Dennis was very upset about the fact that he had been circumcised as an infant, because in Greek culture and also in Colombian, in Ecuadorian culture, by the way, this is not something that is done. And the family went to Greece yearly for vacations, and he felt odd about it. He felt funny about it. He looked different than all the other boys, and this for him was an issue. And the Greek father was just livid about it. He left thousands, and I'm not speaking figuratively, thousands of voicemail messages on my voicemail phone, and I saved them all just in case they were needed, which they weren't. I don't have many more, but I saved them for years. What he would do is call up around 2, 3 a.m. He would stay up stewing over this, and he would just call and leave one message after the other. Once it timed out at about, 3, 4 minutes, he would just call back and leave another one, and then another one, and then another one. And look, I have been doing this work for many years. I have strong feelings about that children should be allowed to make their own decisions about irreversible, not medically necessary changes to their body when they're of the age of consent. But this was just beyond the pale. So, in any event, Dennis was upset, and I don't think this was parental coaching. I think this was actually the kid. He was about 8 at the time. He had a permanent physical scar as a result, and he had been circumcised by a first-year medical resident, which is actually a common thing. What do they say? Watch one, I forget the saying, watch one, see one, do one, or something like that. It's a very cavalier approach, and it results in people who have very little, essentially no training doing these procedures. So that's what happened. And so the case was not a class action. It was just an individual case about Dennis's case. And we brought claims under the 14th Amendment based on a few different allegations. The 14th Amendment basically makes applicable to the states the 5th Amendment. And there's a well-known tradition of using this in case of infringements of parental rights. So that was one of the bases for our claim. It was under Section 1983 of the Federal Civil Rights Protections, which is one of these Reconstruction era laws that basically wasn't used for many decades and then got dusted off in the 60s by activists, civil rights attorneys, and now Section 1983 is pretty commonly used. It's the under color of law, so-called under color of law section. So if someone acts what's called under color of law, which means either they do in fact have state authorization for what they do, or the plaintiff reasonably believes they do, most commonly it's the former, then you can bring your lawsuit, and that was part of the basis for our lawsuit. So we claim discrimination based on both race and national origin, which brought in the federal civil rights claims. We also brought in state law claims, which you're allowed to bring into a federal case based on medical malpractice, gross negligence, intentional infliction of emotional distress, lack of the informed consent, and other claims as well. So we had very good evidence, very good support for our case. We had to have a local attorney, a New York attorney, which neither I nor other co-counsel, the other co-counsel is an expert in the circumcision cases, but not accepted in New York as a lawyer. And unfortunately, our New York lawyer, who had done an excellent job with my other co-counsel in another case, sort of cracked up during this case and did some very odd behavior under the influence of alcohol. And so that was part of the problem with our case, as it turned out, because we were very solid on the facts. But the other problem was that Judge Friedman just really didn't like our case. So he did things that are clearly you're not allowed to do as a judge. For example, the other side would be talking, saying their arguments, and Judge Friedman would be nodding and smiling. Oh, this is great. You're awesome. I like your team. I'm going to vote for you. I didn't say that, but that was the message. And then when we were speaking, he'd scowl, he'd look down, ignore us, telegraphing to the jury of 12, telegraphing to the jury what the proper decision was. And unfortunately, because our local New York attorney was speaking a lot of the time and was out of control, the normal thing you would do is you would call to the attention of the court. We'd like to call to the attention of the court. Your Honor is frowning during our arguments. Your Honor is smiling and nodding during the opposing counsel's arguments. And then that sets you up to appeal if the decision is adverse to you, which it almost certainly is going to be in those circumstances. But unfortunately, we didn't get that on the record. So there's no video of the court proceedings, even in this year, that you can go back and then use on an appeal. You have to have it down in the stenographer's record. Well, I mean, this was 2002, so I don't think there still is in 2020. I'm not a trial lawyer anymore, or I never really was, except for these two cases. But certainly in 2002, there wasn't. So that made our life very hard. I'm looking at my notes and seeing what else I might want to mention. Oh yeah, the Latino boys were targeted for circumcision based on their parents' surnames. Appears to have been the main way that they did that. So that pretty much brings me to the end of the first part of this story. There's more that could be said, but there's a whole story there that's applicable beyond this case of how judges really aren't impartial on this issue, regardless of your own personal standing. And I mean, in this case, the judge happened to be Jewish. I mean, it could have been equally biased if the judge had been non-Jewish. It happened to be the case that he was. And I'm reminded about the very different, but also about circumcision case that happened in San Francisco when there was a ballot initiative to bar circumcision, and wasn't even allowed to proceed, and the judge was also very biased against the case. So that was another sad chapter in the movement. So fast forward to 2018, one occasion when the Commerce Clause wasn't allowed as an excuse for the federal government reaching into territory that otherwise would be considered the state's area to rule. However, was in 2000 when, in the United States versus Morrison, the Supreme Court held against the government, saying that the government had sort of been continually expanding this use of interstate commerce, and in the case of the Violence Against Women Act, the connection to interstate commerce was just too tenuous, and this wasn't going to be allowed as a grounds for the Violence Against Women Act. So that was in 2000. So Judge Friedman made a similar decision. He said the connection between female genital cutting and interstate commerce was just too tenuous to allow the federal government to be regulating it. And interestingly, the federal prosecutors agreed, because they didn't really try to present a case that would overcome that. So there were letters sent to the federal government and explanations of what could be done to pass a new law against female genital cutting that would pass muster by drawing greater connections to areas that are proper for the federal government to regulate, such as use of the post office, for example, to commit female genital cutting, use of other use of the highway system. It does come down to a bit of an odd shell game because, of course, female genital mutilation should already be illegal under current existing laws against assault, sexual abuse, and numerous other laws, as, by the way, should male circumcision as well, if the law were properly interpreted. So in any event, we've had a history of these sort of differential positions on male cutting and female cutting, the sort of differential position that Judge Friedman had. We saw the American Academy of Pediatrics in 2010 in a somewhat notorious series of events pass a statement saying that symbolic forms of female genital cutting that didn't remove tissue were actually permissible, and there was an outcry against that, and a month later they withdrew their statement. And then in 2012, a regional judge in Germany made a ruling that circumcision was unlawful, and the German legislature then overruled that and said that circumcision was permitted, ritual circumcision was permitted. So there you have it. It's an issue that has produced very intellectually tangled, complex, nonsensical series of results, even from the same body, the American Academy of Pediatrics, Judge Friedman, Germany. These were two different entities in Germany, but it's an emotional subject. It's an odd subject. I've been working on it for 24 years. Still fascinates me. I've been to pretty much every subject library at the University of California, Berkeley campus, medical, anthropological, historical, you name it. I've been there on this topic. I think there's one maybe I haven't been to. Maybe the music library hasn't been applicable. So we also had an interesting decision come out of the UK. It's now been 5 years, but Sir James Munby ruled in the case of two unnamed child plaintiffs, a boy and a girl, both of whom have been subject to cutting, and so it sort of brought Judge Munby face to face with what he termed the curious aspect of British law, that the girl's cutting, even though objectively less traumatic and having fewer long-term consequences, was treated more severely by the law. And so Judge Munby commented on this, and part of the decision is not probably precedent law. Part of it arguably is. I'm not a British lawyer, but that's what I understand. Regardless of that, the law has been forced to confront this disjunction between male cutting and female cutting, and then there's intersex cutting, which complicates the picture further. And I think in our very one step forward, two steps back way, we're moving toward harmonizing things, and people are coming to believe, scholars, legislators. We have at least two countries, Denmark and Iceland, that are somewhat close to passing some sort of regulation along these lines. We had San Francisco's law that was overturned in the courtroom, and we're getting there. And so there's two options to harmonize things. We can have boys protected from genital cutting, or we can have minor forms of female genital cutting allowed, which is the direction the AAP went in that 1 month between April 2010 and May 2010. Well, very few of us are advocating for cutting girls. Most of us are advocating for making boys and girls safe. And you know what, folks? Males are not dropping dead in Denmark, in Germany, in the UK, from the ostensible dangers of not being circumcised. They're just not. I mean, you can check the health of males in Europe, and you'll find that it's actually higher than the health of males in America, and also specifically focused on Genital issues. You'll find that males are doing at least as well and probably better in the countries that don't circumcise, which actually, if you step back and think about it, it's not very surprising. We're taking a knife to a kid that doesn't need it medically at a very young age, and it's just this odd thing that's left over from a combination of our 19th century medicalized history and the fact that two of the world's most common religions have done it for religious reasons, and there's some inertia there, some cultural inertia, some social inertia. But guess what? We're in 2020 and things are changing. It's an exciting time to be alive. It's, of course, with COVID, it's also a very challenging time to be alive for all of us. We're moving toward resolving these things. So in Switzerland, there have been two recent cases that have basically restricted parents from performing circumcision. Now, the cases could perhaps be somewhat reduced to their facts in the sense that the more recent case of the two involved a child who was unusually sensitive, and that was part of the reason for the court's decision. At the same time, courts are moving toward understanding that these procedures cause harm. The UK judge that I referred to earlier found that male circumcision also constitutes significant harm. Those were his words. And Judge Munby also noted at least some forms of type 4 circumcision, which is the least harmful of the four. For example, pricking, piercing, and incising are on any view, Judge Munby said, much less invasive than male circumcision. Judge Munby followed this to the logical conclusion that male circumcision must also be a significant harm. And Judge Munby appeared to be perhaps a little bit ill at ease with his own conclusion. He then suggested two possible rationales for treating the two differently. These two rationales we've heard in the past many times: health and religion, both of which can be pretty easily disposed of. The religion is the child's right to decide when they become of age, and all health rationales have failed. And we notice this interesting fact that HIV is just completely been disproven, and UTIs are more common in girls than boys. So why is there this desperate urinary tract infection? So why is there this desperate attempt to find health rationales? Well, it's this procedure that we have from a time when we didn't care about the health rationales. So there you have it, a procedure that has its roots back in the 19th century and thousands of years ago. And here we are in 2020 scratching our heads. How do we justify it? Well, honestly, you don't justify it. And the Canadian Pediatric Society came out with a sort of middle ground position statement that was against circumcision, not as resoundingly as pretty much everybody else outside of North America who's addressed it has been. In Europe, there was a consensus article by 90 experts or so recently confirming what every European Medical Association has been saying, and Australia and New Zealand for a long time, which is basically, come on, world, there's no reason for this, there's no justification, medical, cultural. And people like Justice Munby just look at it, it seems strange, like, why are we still doing this? There's got to be a reason. It's got to be cultural or aesthetic. Well, all those reasons can be applied to female cutting too, except they're not, because the developed world does male circumcision, at least parts of it do, and doesn't do female circumcision, and there you have it. So it's funny about the American Academy of Pediatrics, because they're the one organization that has come out with a statement. Even they don't come right out and favor circumcision. They ostensibly leave it to the parents' judgment, which is itself is odd. I mean, what other medical procedures do we leave to the parents to decide? None. Well, why is that? Well, circumcision isn't really a medical procedure, so there you go. So the AAP says the true incidence of complications after newborn circumcision is unknown, and yet they somehow say that balancing benefits versus complications and intrinsic harms, somehow that balance comes out in a way that might allow it, at least in cases where the parent approves. Well, how can that be? How can you take an unknown and balance it against other considerations? You can't. So this puzzle is just not explained by the AAP because it can't be explained by the AAP. And this is their position statement, which it took them many years to produce. It came out in 2012, and it's now obsolete anyway because those positions have a 5-year horizon after which they're not binding anymore. So there's just puzzles everywhere you look in this issue. It goes on and on. One of the members of the AAP task force is this man who talked about circumcising his son on his parents' kitchen table on the eighth day of his life. But I did it for religious, not medical reasons. I did it because I had 3,000 years of ancestors looking over my shoulder. Well, let's see. Are we still stoning adulterers to death? That has tradition on its side. I mean, the mind reels. Are we still bleeding patients? That's only hundreds of years old. It's obviously no justification at all. So let's step back, folks. Male genital cutting, female genital cutting. Males and females hit different places in our minds, at least most of us. There's a lot of tradition that leads to us having trouble being objective. It's 2020, and you know what? Soon it's going to be 2021. And guess what? If we had anything to spare with our medical dollars, with costs rising and COVID a problem pretty much the world around, we don't have that luxury anymore. And it's just so astonishing that any circumcisions can go on in a world like the world we're in today. So what about equal protection? What about the concept of treating males and females differently? There was recently a federal case that decided that the Selective Service, which of course compels registration for the draft of males but not females in the U.S., was unconstitutional for violating equal protection. Seems like a pretty easy case, right? Mark Angelucci, who actually is a former board member of Attorneys for the Rights of the Child, my organization, and who was tragically assassinated a few months ago for his civil rights legal work, his amazing civil rights legal work, some of it pertaining to circumcision issues, the majority of it not. In fact, Mark and I had a case together in Los Angeles, the other case in which I was a trial attorney other than this one I'm describing. And in any event, we're seeing that equal protection is being viewed as what it has always said that it is, protection that should protect males as well as females, everyone from unequal treatment on account of gender. And of course in the West we have the bias that it's better to stop circumcising males rather than to start circumcising females, which I don't think will make many people happy in the US and in the developed world and elsewhere. So this has been an issue that's been very exciting for those of us that have been involved for a number of years, very interesting. When I first started in 1996, I didn't talk about the Convention Against Torture as being relevant to considerations in male genital cutting. A few years ago, it started to feel right to me to start doing so, and since that time, the Convention Against Torture has been invoked against intersex genital cutting, which I think is correct. And as a culture, as a society, as human beings, we're more and more delving deeper and ascertaining if we're willing to consider and countenance procedures that may permanently change an individual's body, change their treasured body parts in a way to which they never agreed, without medical need and forever, irrevocably, until the day they die. The time is now to say yes to genital autonomy, a term I haven't mentioned previously today, but a term referring to the ability of all people to make decisions about their own genitals and bodies upon reaching the age of majority. The time is now to say yes to genital autonomy, yes to equal protection, and no to unconsented, medically unnecessary genital modification procedures. I'm grateful to live in a world that's evolving in awareness. I'm grateful to live in a world that's more and more opening up to the concept of fair gender treatment for all, males as well as females, on all grounds. I'm very happy that issues that women have had in the past have been very effectively addressed and are continuing to be addressed. And I'm also very happy that issues that males have been having, while I feel like we're in a more nascent stage, that is also starting to be understood. And fair treatment of domestic violence from both sides is being embraced more and more. And this is another phase of it, and an important phase of it. It's the first childhood message that a child gets when they're cut within the first few days or weeks, or even if it's months or years of their life. We're going to say no to that, and that's an exciting thing for me. I want to thank everyone for being here and listening, and those of you who are still listening have sat through this whole talk, and I've really enjoyed it. It's the first time I've done this, and I'm looking forward to a great event. Thank you. Bye.